all LLCs are created equal, right? I mean, if you buy a rental property, can't you just throw it in an LLC and it takes care of you? Listen, today I want to talk to you about 5 LLC mistakes that could destroy your real estate portfolio. And in fact, here are these 5 common mistakes, and I'm going to jump right into it. I'm going to share my screen with you very quickly. And I'm Jeff Hampton with STR Law Guys, and I want to share with you a few points here that I see a lot of people make mistakes on. So let's say hypothetically, this is what we're looking at. Okay. Let's say we have a Florida beach house. Now, with this Florida beach house, let's say you now have to make a decision. You purchased a beach house. Where do you do with it? You've heard under different things on the internet and on YouTube that Wyoming LLCs are pretty good laws. Maybe that's what you should do is move the property into there. Maybe you should transfer the property into a Delaware LLC, maybe a Nevada LLC. And maybe you've even heard about the Arizona Limited Partnership as an option. Now, look, bear with me, my terrible writing on this, trying to use my mouse. But to do a little whiteboarding here for you, let's examine where should it go? We have a big question mark right here. Most people that I talk to, they have this misconception that they believe I'm going to choose a preferred state's LLC laws and I'm going to move my property into the ownership into that LLC. And if I do that, I'll be able to borrow those states' laws and I'll be able to obtain the benefit of those state laws, even though my property's in a different state. Here's the problem. The Florida beach house is in Florida, right? So there's something known as home state rules control. So that means even if you were to move this Florida beach house into a Wyoming LLC as the owner, right? As let's say you literally do a deed transfer into the Wyoming LLC or any of these other for that matter up here on this top level right here. The problem is if you do that, you cannot now borrow Wyoming's laws or Delaware's laws or Nevada's laws or Arizona's laws when you end up getting sued. Because here's why. Your property is in Florida. You're going to be hauled in front of a Florida judge in a Florida courtroom, and a Florida law is going to be applied to this situation. So as a general rule, what do you do in this situation? It makes sense to make sure that you move the property. You need to make sure that you move the property ownership into a Florida LLC. Okay. Really important. There is no longer a question about what you should do here. The standard here is very clear. If you try to move this into one of these other LLCs up here to transfer your assets into here, you are receiving no additional benefit. In fact, you're going to end up having to pay foreign registered agent fees. It's going to cost more to maintain that LLC. So it's important to understand that's one of the biggest misconceptions. Do not just go choose a preferred state's laws to move a different state's property into it. It won't work. So number 2, let's also talk about California for a second. I'll go back. We'll come back to our screen here in a minute. Let's talk for a second about California law. A lot of times I talk to people and they think they're protected if they move a property that they own in California into an LLC by itself. Now, let's say you are in California, maybe you're investing in Joshua Tree or another place in California, and you set up an LLC and you transfer that rental property into a California LLC. Well, unfortunately, California has some of the most plaintiffs-friendly laws in the entire country. If you own a property in California, do not think for 1 minute that you are protected from a lawsuit by merely having the property in an LLC. It won't work out that way. It won't be quite what you hoped it would be. It is critical that you move your property that is owned in a California LLC to be owned by a holding company in order to provide you asset protection. And that provides a good segue into mistake number 3. So mistake number 1 was borrowing another state's laws for your property and trying to set it up in a beneficial state right out of the gate. Number 2 was to believe that you're protected in California if you put a California property in an LLC. Very little protection at all. Number 3 is setting up the wrong state's LLCs for your holding company strategy. Now, what is a holding company strategy? Let's talk about this. And I'm going to share my screen again with you. This is talking about having your Florida property. We know here that the Florida property has now been moved into the Florida LLC. Okay. We know that. So now that's where the deed transfer is. But is it okay to just have that Florida LLC be the primary owner and that's it? Stop right there. Well, unfortunately, there are 2 things you do not have if you leave that property in only a Florida LLC. Number 1, you do not have privacy. which means if an attorney wants to sue you in Florida, that attorney can go to the Florida Secretary of State and find out, number one, that you're listed as a member on that LLC, and that destroys all of that. No privacy, no anonymity. So as a result of that, the attorney is going to profile you and find out what kind of target you may be, and that elevates your risk level. Number two, you do not have charging order protection, which essentially what that means is that a lawsuit could be brought against you against that Florida LLC. And if you lose, the attorney could force a sale of that property in order to gain any of the equity and anything else within that LLC that could help pay that judgment. So now what do we want to do is make sure we set up the right state's LLC. Now, here's what I see a lot of people do. And honestly, it's just bad information that they learn from somewhere off the internet or a local attorney. Many local attorneys within a state don't always know about holding company strategies. So is it okay now to potentially just set up another Florida LLC right here? What if we set up another Florida LLC and have that Florida LLC now owned as a holding company, right? So this is the holding company here. Now I see a lot of people do this. They'll have a Florida beach house that, actually I did this the wrong way. Let me delete that real quick. What they will do is they will actually have it set up this way. They will take a Florida LLC holding company and have this LLC now owned. Oh, sorry about that. Have this Florida LLC now owned by this Florida LLC. So this will be a single member. Can I tell you, stacking LLCs on top of each other provides you no additional asset protection at all. So now is where you can use a particular state's beneficial laws. This is critical. This can actually work really well. So now what you start doing is saying, okay, wait a minute. Now we know Wyoming and Delaware and Nevada do provide, as well as Arizona, provide some additional benefits here that I won't find anywhere else. So let's just be real clear. First of all, stacking one state's laws on top of another is not providing any additional asset protection. So we don't even want to consider that, even though I see that as a mistake that a lot of people make. So the way this would work is if you want to use a particular state's beneficial laws, you could have this Florida LLC that owns your beach house to be a single member LLC, and that single member could be either a Wyoming LLC, right? Or it could be a Delaware LLC. It could be a Nevada LLC. It could be a Arizona limited partnership, okay? Now, by doing this, what are you obtaining? Particularly for Wyoming, Delaware, and Nevada, what are you obtaining from there? And particularly Wyoming and Delaware. We really spent some time on that. We could get into Nevada as well, but primarily Wyoming and Delaware, what are we looking at here? Number one, two big benefits. You now will have privacy, okay? So by doing this, essentially what happens is if, sorry about that, little glitchy with my mouse. If you end up having the situation right now where a Florida attorney wants to begin looking at the Secretary of State, the Florida Secretary of State, here's what they're going to find out. They're going to find out that the owner, the single member, is actually a Wyoming LLC. They're then going to go to the Wyoming Secretary of State, and what are they going to learn? They're going to learn, oops, no, hold on. Wyoming has special privacy laws that are beneficial that they will not disclose the names of the members. So now you have privacy. People are not going to know that you're associated with this. Completely private. Number two, you'll have charging order protection, which means now, even if you were to be sued in Florida, this LLC here, and you were to lose the lawsuit, you now have charging order protection, which means you cannot be forced to sell the property. And can I tell you why that's important? Having been a former personal injury attorney, it's important because personal injury lawyers get paid on a contingency fee basis. If they look at a situation like this and they see that you have a holding company that owns your Florida LLC with your property in it, and they can't make you sell, personal injury lawyers get paid on a contingency fee basis. That means they got to pay for all the expenses of the lawsuit out of their pocket. And if they don't recover, they don't get reimbursed. They don't make any money. Their client doesn't make any money. That makes you a very unattractive target. So good asset protection always pushes lawyers down to good insurance. And that's what you need to have in this situation. This provides you both privacy, and number two, it provides you charging order protection. Okay. Two big benefits here, not to just stop right where you're at with an LLC in Florida. Okay. Now, finally, we talked about those three things. Number four, be careful setting, and here's another one. I'm going to stop out of this real quick. Be careful setting up a single member LLC. There's so many people that I see that make this mistake. A lot of people will work with their accountants. Accountants do it all the time. Look, accountants are focused on your tax strategy. They're not focused on your asset protection, just like I would never do your taxes for you because I'm the attorney. I'm not your accountant. The important thing to do there is to make sure that you understand if your accountant is recommending a single member LLC is a disregarded entity, and many disregarded entities can also be disregarded by courts. So it's really important to understand that if the IRS disregards, there's a decent chance that the court is also going to disregard. The solution is to set up what I talked about a minute ago, is to set up single member LLCs down here that do what? Now you have a single member LLC that is owned by a holding company. So now you have the tax efficiency, but you also have a holding company from the right state that provides you privacy and charging order protection as a result of that. Finally, mistake number 5 that I see people make is assuming that an LLC is the only option or the best option always to set up a holding company strategy. Now, there is another option that is out there, and it is known as the Arizona Limited Partnership. And there are other partnerships statutes that exist in other states. But I can tell you one of the great things about Arizona, when you start looking at this as an option, Arizona Limited Partnership provides you some of the same benefits. And I'm not going to go over this too in depth on this particular video. I'm going to save that. I'm going to refer you to the video that I'm showing here on the end screen. I want to encourage you to go watch this video in depth. It gives you a very deeper understanding of how the Arizona Limited Partnership provides one extra component to this. And that one extra component is post-lawsuit flexibility, okay? So what I want to do is I'm going to add this on here for you to look at. This piece right here, number 3, post, and I don't know if I can draw this right because my mouse is acting strange, but lawsuit flex, right? So that's what you're going to get here with only the Arizona Limited Partnership, okay? And I encourage you to go back and watch this video, but this is a mistake that I hear people make all the time, is they assume only an LLC can provide their growing portfolio, that holding company strategy can only come from an LLC. The reality of it is, if you are scaling your portfolio, if you're getting over 4 properties, getting bigger and bigger, you should check out this video on the Arizona Limited Partnership. You'll get a much better understanding of how it is ideal structure that integrates a trust as well as 2 pieces to it, where there's an actual opportunity to create post-lawsuit flexibility to mitigate your risk, as well as taking care of your estate planning. So I wanted to walk you through those top 5 mistakes. In summary, number 1, choosing a preferred state LLC law to move the property into. Remember, that doesn't work. Number 2, setting up a California LLC and thinking that protects your California property. Nope, it's not going to cut it. Number 3, setting up the wrong state's LLC for your holding company strategy. Remember, you got to pick a beneficial state to have the holding company set up in. Number 4, setting up a single member LLC without using a holding company. Huge mistake. You're not getting much asset protection. Finally, number 5 is only considering an LLC as your primary strategy for your holding company. Check out my video that I'm including up here now on the end screen on the Arizona Limited Partnership and see how it might be a good fit for you. Thanks for joining today. I'll see you on our next video.